These scams, see, like for example, Harshit Mehta, the entire capital markets scenario then was very loosely regulated. It led to somebody taking advantage of the system. You had a scam. The Indian judicial system has been such, which we all know. Very loosely, people say that in India, the one generation files a case, the second generation fights it.
So it's only done by the private players or the governments also?
This is what I think you want to go viral now with this. Please read the contract. Please read the terms that you're signing in for. Basically, for that 10 lakhs, I've written my skin. People who are working with you, they leave you and go. They can just take away with your clients, your intellectual property, your ideas, your data. What would you do? Indian ethos, the way we have been working, the way we have been conducting ourselves, ki pay money, get the job done. These scams, corruptions, scandals, we saw them even as late as 2008-9, and unfortunately, as much as you may like it or not, if truth is to be spoken, there is a nexus of.
Hello guys and welcome back to AP Podcast. Thank you so much for tuning in and thank you so much for giving in so much of love and support. और बात करूँ आज के podcast के बारे में. If I honestly speak about today's podcast, this is for the first time that at AP Podcast we are having someone from the background of economics, not an economist, but a very seasoned lawyer. आज के जो हमारे गेस्ट है वो है अनंत मरथिया. आनंद सर के साथ जो मेरी ये कन्वर्सेशन थी वो काफ़ी वास्ट रही. Provided Anand sir is someone who is a very seasoned lawyer and is also the author of this very famous book, Defaulters Paradise Lost, which basically talks about the various aspects of Insolvency Bankruptcy Code. अब मैंने इतना मोटा टर्म आप लोगों को सुना दिया तो हो सकता है आप लोगों को इसके बारे में नहीं पता हो, मुझे भी नहीं पता था. मेरे जैसे आपके जैसे लोगों को ये लगेगा कि ऐसे कोड्स, ऐसे बड़े बड़े रूल्स मे भी बड़े बड़े फेडरेशंस, कॉरपोरेशंस के लिए लागू होता है, बट ऐसा नहीं है. आफ्टर दिस कन्वर्सेशन आई रियलाइज द फैक्ट that small little details from your little memorandum of understandings to your little contracts that you sign for getting a loan, a car loan, maybe a home loan, maybe an education loan, आप कुछ भी उठा रहे हैं, उसके पीछे की रीजनिंग क्या है, कैसे इतने बड़े मनी लॉन्ड्रिंग स्कैम्स होते हैं, कैसे एक मिडिल क्लास को कॉन्ट्रैक्ट्स के नीचे दबाया जाता है और कैसे जो बहुत ही ज़्यादा हायरार्की में ऊपर लोग हैं वो एक के बाद एक हजारों करोड़ों का स्कैम कर लेते हैं और उन्हें कुछ होता भी नहीं है. ये जितना भी नेक्सस है ये एक बहुत ही बड़ी पॉलिटिक्स और बहुत ही बड़े फेडरेशन का पार्ट है. तो इस पॉडकास्ट में हमारी कोशिश रही थी कि एक अनबायस्ड तरीके से हम बहुत ही लेंथी और बहुत ही एनरिचिंग कन्वर्सेशन आप तक पहुंचा पाए. तो आई रियली होप आप इस कन्वर्सेशन को एंजॉय करेंगे. हो सकता है दिस कन्वर्सेशन माइट सीम वेरी हैवी. टू बी वेरी ऑनेस्ट इट डिड टू मी एज वेल, बट आई रियली रिक्वेस्ट यू, इफ यू आर समवन हु रियली वांट्स टू अंडरस्टैंड हाउ द इकोनॉमिक्स ऑफ दिस कंट्री वर्क्स एंड हाउ these big money laundering scams work and how you can save yourself from these scams, this is the podcast for you. So with that, AP Podcast rolling in 3, 2, 1.
First of all, Anand sir, thank you so much for coming to AP Podcast. I think you're one of the first people we are having, not an economist I'm telling you are, but from sort of this background, that is economy and finance. So welcome aboard and thank you so much for being here.
Thank you for having me over, Aftab. So let me clarify. As you rightly said, I'm not an economist, I'm a lawyer. But the book that I've written or the subject that I speak on is basically something that connects law and economy in one way or the other. So yeah, that's that. Thank you. It's absolutely a pleasure to be here.
And starting this conversation, let's start it with this book's title only. However, you have given the clarification that what's the reason behind that title. It was somewhere related to a particular case and a judge had used this particular sentence, paradise lost and all that stuff. So honestly, this paradise lost really caught my attention. I am someone who is from English background, as in literature. So this paradise lost is so philosophical in its own terms that you can make multiple interpretations out of it. However, I would also like you to share the reasoning for this particular title. But with that, I think in this country, people just don't want to respect the Indian law, or they don't know what is the power of Indian law. So if you can just touch these two topics for the initial start, I think that's what the viewers would really like to hear.
Be happy to. So to take part of your first question, the first question in terms of why and how this particular title. So yeah, we all know Paradise Lost is John Milton's, if I'm not wrong, one of the best
Yes.
works. You rightly observed. I was very much inspired by this particular term used in a particular judgment, wherein the constitutional validity of the Insolvency Code, the particular law which we're talking about which the book is, that was challenged in the Supreme Court. And the then Honorable Judge who wrote that judgment, Justice Nariman, he very beautifully put it that the defaulter's paradise in India is lost, and the Indian economy has rightfully gained its position or gained its rightful position, which means that which indicates that India was, at least for the last maybe couple of decades, a paradise for those who wanted to default by nature. Take it for granted, take it easy, take the monies from the banks, don't give it back. So that defaulters' comfort zone, paradise, or it was their, I would say, yeah, comfort zone I think is the best term to say, nearest to paradise. That seemed to be lost. And the reason why that statement was made is the impact of this particular law, which I presume we will discuss as we move forward. So that caught my attention, and I said, "Nee, theek hai, there should be a book which should bring this out to the people. A book which is, yes, written by a lawyer with possibly a degree in economics, but it's not a heavy legal commentary. So there's this mindset that people have that, all lawyers' books and legal books are very heavy to read, and it's very, I would say, technical in nature. See, without being technical, we can't explain, but then at least what we've done, at least the effort that I've tried to put together in this book, is the first half of it is at a broader level, where an absolute non-lawyer should be able to relate to it and understand, giving a perspective, what were the challenges, why a particular law was needed, and why that law was impactful enough to deserve this title. Of course, the second part of the book is with respect to each stakeholder, the impact of the law on stakeholders. So that is with respect to the title of the book. With respect to the second thing, that in India people tend to not respect the laws so much. That is changing. At least I believe that's changing over the last 8-10 years. But even having said that, there's a long way to go, really, really long way to go. The Indian judicial system has been such, which we all know, very loosely people say that, in India, the one generation files a case, the second generation fights it, and the third generation possibly sees the result of that case. That's a lighter vein saying amidst, I would say, sometimes people have come up to me and said this. Civil cases, yes, sometimes it does, because the procedure is not that the procedure alone is long, but it is a bit of that colonized old style procedure, fairly detailed, so on and so forth. But also enforcement of the law, enforcement of contracts, enforcement of the law per se has somewhere been one of our, I would say, weaker points in the initial 50-60 years of
Is
our...
it because of colonization also?
Colonization, I would not directly say that it is because of that, but I would definitely say that the laws that we have today, at least a large part of our procedural law, which is now undergoing change, the criminal laws have changed, the new laws have come into place, which is more modern in nature, which speaks about the more relevant issues, more contemporary, I would say, acts which come under the purview of what you can call a crime or something which is wrong. The laws which have been there since, because see these laws, like for example, I'll just give you an example: Contract Act, 1872. Now, or for that matter, any act of the 1800s, the 1900s, early 1900s, were they brought in to really govern a larger nation like India, or were it brought in by a particular company, the East India Company, to ensure that they are in power? They, I would say, one step beyond governing people, they punish people where they're wrong, so on and so forth. But it would not be fully right to say that it is just because these are old laws, the enforcement is weak. There have been certain loopholes in the overall enforcement process over a period of time. Pendency of cases, shortage of infrastructure in the judiciary, a lot of other issues. We can discuss about those. But also the mindset of people, because people have with time seen that things go on for years and years together. And for example, you talk about scandals which involve lakhs and lakhs of crores.
Money laundering, basically.
Money laundering, lakhs of crores, where there are politicians who've been involved and so on and so forth. How many of them have really been jailed? How many of them have really put behind bars for a really long period of time? The process just goes on, the trial goes on, the person is sitting outside an anticipatory bail. So generally there has been a perception, but now, at least from the commercial laws perspective, which is an area where I work closely with, things are changing. Businesses, companies, entrepreneurs, they all definitely are a lot more, I would say, respectful of the laws of the country, and they should be also, I think.
Okay, so it was not, let's say, 10 years ago?
It was lesser.
It was lesser.
It was way lesser. If you want to, I mean, depends on what. If you're asking it from the angle of laws relating to finance and economy, for example,
Yeah.
Or commercial laws. Most of the laws that were around, or some of them are still around, they didn't have specific timelines, time periods to be where the process has to be completed. The punishments were not so stringent. The enforcement of those contracts was not taken up so seriously. So a lot of this has changed in the last 7-8 years. Of course, as I said, we still have a long way to go. We can't be complacent to say, yeah, now we are way better off, and we have a lot more technology to use. As they say, the justice part of it has to reach the last mile. It's not anywhere close there yet. But today you have enabling facilities, like you have, for example, a small example, video conferencing facilities. Today a person from a relatively remote place can attend an online hearing in one of the courts. It could be, of course, a high court or a certain lower court, not in all courts. But as these things progress, as technology progresses, people are able to attend hearings from different places. There is more ramping up of judicial infrastructure. See, what is enforcement? What is law enforcement? Or it's basically, if you have the infrastructure, it's only then you can really go behind people who are defaulting in the laws. When you don't have infrastructure itself, you shortage of judges, you have shortage of support staff, then what do you do? And that naturally means cases keep getting adjourned. And as we hear this common word, tariq pe tariq kind of a thing, where dates are given. So a lot of that can improve. If it has to some extent, but a lot of that needs to further improve to ensure that there's actually the rule of law in this country is respected by the citizen.
But a good chunk of this thing that you're saying, that money laundering has reduced a lot in this last 1 decade. Do you feel a major reason is the sudden shift, or let's say not even sudden, because of COVID, to online payments? Even pre-COVID, obviously we had, but now with online portals, banks operating online, RTGS, UPI, multiple things coming in form of online payments. Has this increased the regulation more, because everything is supposed to be more transparent?
I will answer this part of the question, which is, I would say, one aspect of it. The aspect of money laundering and not paying back the banks, it's a different subject altogether. not paying back the loans taken from the banks, and that being a different subject, but which has changed. That is where a larger change has happened, where the results are in lakhs of crores, evidently, which is data is available. But even this has actually helped. See, when you look at demonetization, coupled with post-COVID or during around that time, the strengthening of our, as they call it, the jam trinity, the Jan Dhan thing, Yojana, the Aadhaar, and the mobile
Jan Kalyan Yojana, basically.
Jan Dhan Yojana,
Jan Dhan.
which is basically where you have bank accounts for every single person. They've been encouraged to open bank accounts. The Aadhaar card concept, which is one single identity concept, and the revolution on terms of the 4G, 5G technology. So these put together, yes, definitely UPI payments, online payments have gone up significantly. As they call it, the parallel economy has come down to a large extent. And today you go right down to the, a tier 3 place, or even a smaller, I mean, I cannot say it's a village or not, but then definitely very small towns, they're accepting UPI payments. So the usage of cash economy, usage in the economy has definitely come down. But to say that has reduced money laundering per se, to some extent, yes, but not the only reason. But definitely this has been I mean, it's nothing short of a game changer either. Because you are obviously cutting down the movement of cash, which means that generally the flow of cash into the economy, where if there is one sector of people who are accumulating it, it also goes down.
I mean, it's like a proper catalyst sort of thing that these online payments have become. Okay. And moving towards IBC, which pretty much is covered in your book as well. So IBC, when I read about this, I think to a general person, this may sound to be a very complex thing. So for the starters, before we actually get into this topic, I'd really like if you could explain what IBC is about.
Okay. So the full form of IBC is Insolvency and Bankruptcy Code. So first of all, the name itself is a little, I wish at some point in time the government thinks of renaming this law as the Restructuring of Distressed Companies Act or something like that, or Distressed Companies Code or whatever it is, because both seem to be a little bit of a negative connotate words. These connotations are a bit negative right from day one. Insolvent, bankrupt. Nobody wants to be associated.
Controversial keywords.
Nobody wants to be associated with these terms. But so this is a law which was brought in by 2016 by the present government. But one has to go a little bit in the, I would say, previous 10 to 15 years of history to understand why you needed a law like this. If you would have asked me in one line, so why did we need a law like this? It was required for a cleaning up of the banking system. When I say cleaning up of the banking system, there were basically banks that were not recording loans which have already gone bad as bad loans, as non-performing assets, and a lot of it was being put under the carpet for certain reasons. The simple reason was the bank's balance sheet also, as on 31st March, had to look healthy, and the company which is the borrower, which has to give hundreds of crores to the bank, doesn't want to also be seen as a defaulter. So if I can say, this was some kind of a nexus also to some extent at that point in time. Things have changed after that to a large extent. But see, with the 1991 liberalization, privatization, globalization reforms that happened, India started growing well in terms of business. That decade was good. Your GDP went up, your growth of business went up. Then again from 98 to 2004, you had a reasonably stable government of the NDA then. Vajpayee ji was the Prime Minister, things went fine. And the work done around that time saw positive results where good positive GDP and all of that was seen till about 2008-9. Then you see a 2008 crisis, the global financial crisis that happens. Now, there are two things that happen at around the same time. In this phase of 2004-5 until 2009-10, there was significant amount of heavy-duty borrowings, indiscriminate lending by banks, and indiscriminate borrowing by businesses without proper business plan, without any, I would not say every.
This was only done by the private players or the governments also?
The government sector banks also.
Huh.
The government sector
Specifically
banks.
banks only.
Banks, primarily the banks.
Hmm.
The government, the public sector banks, of course, some private sector banks also, to companies, to it need not be the biggest of industrialists, but it was to industries, to companies, to businesses. Now, things were going fine till 2008-9. See, a lot of business projects after 2005, 6, 7. I think the first tenure of UPA wasn't so bad still. But then you started realize, I mean, rather the nation started getting hit by one scam after the other. 2G, telecom, license, coal allocation, block, this, that. So there was sectoral, I would say, the entire confidence in every sector was getting shaken up. So that had an impact on the telecom sector, the power sector, and all of that. When you have an effect on the power sector, or when you have an impact or slowdown on the economy, iron and steel, all the bigger sectors do get impacted. Now comes a challenge where these companies had taken significant amount of loans, but the deployment of these amounts were not done for whatever purposes these loans were taken. It was done to either just meet the crisis, or, as I said, the other thing was that loans, there was a lot of money, there was a lot of infusion of funds into the system by the government into the banks to save it from the global financial crisis. And in turn, banks were lending to these organizations. I will just pause here for a second. As a startup, if you were to go to a bank and ask for a reasonable loan of 25 to 50 lakhs, I think the bank would today ask you a lot of questions. They would ask you to present a business plan as detailed as possible. They'll do due diligence and all of that. This was something that was missing in the loans given in this period of 2004 to 2008-9. When, with the crisis put together, along with these loans going bad, indiscriminate lending, scams, policy paralysis, where there were no clear decisions being taken, a lot of projects, infrastructure projects were stuck midway, constructions were not happening, highway projects were stuck. So from 2009-10, these loans started showing distress. When you say loans showing distress, which means they either were struggling to repay the interest or to honor their interest commitments, and by 11, 12, 13, they had started turning into non-performing assets. The concern of the banks was, we're just coming out of an economic crisis. Let's not further expose this, which was actually, the amount was somewhere about 6 to 7 lakh crores. Let's not expose these further, that these loans have all gone bad. Unfortunately, there was something called, possibly you can call it evergreening of loans, window dressing of loans, wherein these bad loans, just to ensure they don't reflect as defaulted loans on the account of the banks, the bank would further sanction a small amount to the business and say, I will just, it's more of paperwork. I will sanction you a certain amount and I will take it back as though you have serviced me that interest. I hope I'm clear on this part of it.
Yeah.
So the amount given was technically by the bank to itself, servicing of interest, but then the books of both the parties were kind of
Not clear.
clean. On paper, or clean on paper. Internally, they both knew they were in a mess. So this was continuing. This went on till, I would say, 14, 15, 16, which is where
Before the demonetization, almost.
Yeah, before the demonetization. But this, I would not connect it with demonetization. What happened was the non-performing assets, it ballooned up to almost, I would say, 10 lakh crores plus kind of a figure. And there were a lot of these companies which eventually ran through the insolvency and bankruptcy process, IBC process, SR Steel, the JP Group, which you're aware of over here, and quite a few other companies, Jet Airways, Ruchi Soya, quite a few of the bigger names were there, Bhushan Steel. 30,000 crores, 40,000 crores of total claims, 50,000 crore of claims. I mean, 50,000 crores. How much is that? That's a lot of money 30,000 crores, a lot of money.
That will
And
buy 2 Gurgaon.
but those were the amounts that at least was the amount of claim that was put together by various stakeholders, bankers, when the company ran into the insolvency process. So if a tough law was not brought into place to have a time bound resolution system mechanism wherein you either see, you have to at some point, as they say, to bite the bullet, take the poison pill and move on in life. Otherwise they would have continued this whole, evergreening. How long would you do it? The economy was already, we had gone to a fragile 5 status in 2015-16. From there we are today in the top 5. We are the 5th largest economy in the world. So from a fragile 5 to top 5 has actually been a good journey over the last 10 years. So that is when they came up with this law, because they realized that the previous laws, I won't get into too much of the technicals, but there were some 4 or 5 laws, attempts made, where laws were brought in, but enforcement was weak. People would just go on taking time for years. And when I say years and years, 5 years, 8 years, 10 years. This law initially said whatever it is, one way or the other, in simple words, there should be result in 270 days, which later became 330 days, by which you should either have a resolution, which means some revival of the company, or liquidate the assets, as in sell the assets, whatever comes, pay to the secured creditor. There is a certain mechanism laid down. How do you pay the money to the people and all of that? Well, I have some reservations on the way this money is distributed. We discuss that later. But this actually did show results, at least from 2016-17 to 2019-20. A lot of cleanup happened. These companies were run into the insolvency process. The promoters for the first time got a jolt in India, let's say 2017 to 2021, that the companies can actually go out of their hands. Otherwise, it is like, I will sit over a distressed company, a sick company. I will supposedly run it. Whatever is happening, it's okay. It's at the cost of who? It's the cost of bankers' money, creditors' money, suppliers' money, some government dues which are pending. That's okay, but I will not let go of the company. So I think, to gracefully put it, ease of exit was being introduced through this law.
Ease of exit.
Ease of doing business
for
is one
whom
thing.
exactly here?
Ease of exit for a business which is not anymore viable.
Not profitable, basically.
Not viable, profitable or not, not viable to be done. So that was your ease of exit.
So you're saying that before 2016-17, businesses didn't have this exit. As in, the investor was like a hound investor, कि वो पूरी company खा जाएगा. The company in which he has invested his money, or she has invested her money.
I would not call that person the investor. I would call that person the promoter of the company.
Promoter of the company.
Promoter of the company would not say खा जाएगा, but the promoter of the company was not willing to let go of a business even if it has failed.
But how is that promotion?
I mean, that is the mindset, that was rather the mindset of a business person in India, or a businessman or a woman, or that's the reason I'm using a generic term, the promoter of the company, the person who started the company, or the person whose ancestors or whatever, they would have started the company. They're running the company. They don't want to let go, because there's always a hope that at some point I will, revive, restructure, so on and so forth. So to answer, again, your question is, was there a provision of exit earlier? There were some schemes brought in, like there was something called the BIFR that was brought in, Board of Industrial Financial Reconstruction of Companies. Not very effective. Come back to IBC. In these last 3-4 years, we have seen the Tata's take over the Bhushan Steel. We have seen the ArcelorMittal and the Nippon Group together take up the SR Steel. We have seen Ruchi Soya being taken up by the Patanjali Group. We have also seen something called a Kalrock Consortium taking over the Jet Airways. So third-party acquirers are buying companies which are in a distressed position, and they are then, whatever, they are revamping it, clearing up whatever maximum dues that what that company demands today, or whatever that company's values is there today. And they're trying to revive these companies, so that's going to have a multiplier effect on the business, on the employment that these companies generate.
It's like Tata bought Air India, which earlier it used to have, but it had become a government entity, right?
Yes, Tata's acquisition of Air India was not an acquisition through the Insolvency Code, or it was not a distressed acquisition. There are two kind of things that happen in acquisition of businesses. One is the proper M&A deal, merger and acquisition. where you acquire a company on either friendly terms or hostile terms, but it is need not be necessary that the company that you're acquiring is a distressed company, financially in a bad shape. That was possibly Tata's deal with Air India. But the examples that I mentioned, these were all through the IBC mechanism, through a legal mechanism in the court, which is called the National Company Law Tribunal. So they acquired these companies through these processes, where there was typically what happens is when a company goes into insolvency at a very broad level, first thing is the owner of the promoter of the company loses control, and the board of directors cannot act anymore as the board. They are suspended. The creditors take control of the company through something called the insolvency professional. It's a court appointed officer. They run a process where they get a valuation of the company done as to what are the value of the assets today. They call for bids from the open market. Whoever comes up with good proposals, there's a process is there. There's an expression of interest followed by a request for resolution plan. But I'm just giving it on a very larger, broader scale. Who's whichever I would say acquirer or potential bidders revival plan, resolution plan, whatever word you want to call it, or in simple words, the bid is the most attractive for the creditors, which is the bankers primarily, secured creditors, financial creditors, because they are the decision making authority in this. They then decide, okay, the company can be acquired by so and so. We will get so much of our money, and by the way, they don't get 100% of that money. Some cases they get 30%, some they get 50%, some they get 80%. Depends on what is the liquidation value of that company. Now, again, a technical term I have used, liquidation value.
Yes, I was about to actually ask that.
So, what happens is a company may be worth X amount, let's say sometime in the mid 2000s or the late 2000s or whatever. Loans were given, company's valuation was ballooned, it showed up, it's a 5,000 crore company. All put together, the total balance sheet would say the assets is 5,000 crores and all of that. But in reality, a lot of it would be what we have seen at the ground level. One, monies were actually not in the company, it was siphoned out by promoters in some cases. And second very common issue which we saw in the Indian business ecosystem is that they would show stocks in the books, but in reality when you go to the godowns, the stocks of the material will not be there. So if the stocks are shown, you are in a position to continue renewing your loans and all of that. So today when a proper valuation is done without any bias, a genuine one, you realize that the value of this company is only some 600 crores, 700 crores against supposedly 5,000 or 4,000 crores. So that liquidation value, which is done by a registered valuer, you can appoint two valuers. If there's a big difference, you can appoint a third valuer. All that process is there. Then you come in, these creditors open it up to the market with a base minimum of this amount, and then whoever bids more than that. Of course, there is a judgment also to say that even if an acquisition of a company happens below the liquidation value, it is not per se illegal. But the general norm is that most of the companies get acquired at a liquidation value plus something more. But the unfortunate part of this whole thing is there is a significant haircut, which I'm sure you will again want to know what is this haircut concept, but a significant amount of money that is lost out or which is not recovered by the creditors. So again, this is all connected to the previous thing that we were talking. Your company doesn't actually have assets or value or real enterprise value is not there. But you have, to some extent, if I may say, fudged your books, done things in a way where it appears that the company is doing well, and you are just slowly inflating the valuation with time. But the day things go bust, you realize that there's very little content in the company. But this is not the case for every company. Some companies still have a reasonably decent liquidation value compared to the total claims sought for. And recoveries are happening. And then this will possibly take us to another subject of what is the concept of recovery in this insolvency code? Is that the procedure? Is that what the law is for? Because there's always a debate that is this law for recovery or is it for revival? And the courts have time and again said, don't look at this law only as a recovery of your money law. to the bankers, to the financial institutions. It's a law for revival of companies
Revival of companies who have become dead.
who have gone into a financial distress. Yes. That is possibly the extreme case scenario.
Or have been acquired by big corporate houses.
So when the companies are in distress, they as part of the process, they tend to get acquired by these houses, big corporate houses.
But as much as I'm trying to understand from this whole IBC thing, is this something which only favors people who are business professionals, or it has something to do with the common crowd, which is might be working in a job, to the middle class, to the lower class people? Does it affect these type of people also?
It actually affects everyone.
Okay.
Now, you can look at it both ways. To the people who run businesses, it can be both beneficial. It can be beneficial if you are a potential acquirer. It is also sometimes, if I can use the word, misused by some of the businesses which consciously ensure that they run the insolvency process. They go into bankruptcy, insolvency, or whatever it is. And through some third party company, they acquire their own company at a very nominal value by clearing up all the other debts, by giving something called what you call a heavy duty haircut to all the other stakeholders. Now when I say stakeholders comes in your question, who are these stakeholders? Financial institutions, they are part of the decision making process because they are something called the committee of creditors. Workmen and employees usually workmen gets up to 24 months prior to the date where the insolvency has started. They get their dues. Their dues are supposed to be provided as per the law itself. Employees are supposed to get 12 months of their past dues, up to 12 months. Suppose insolvency has started on 1/4/2018. From 1/4/2017 to 1/4/2018, that previous 1 year of dues has to be given compulsorily to employees. So workmen and employees are financially, yes, reasonably protected, but there's always a sort of uncertainty hanging on them whether the company will continue or it will go into liquidation where the assets will be sold, whether the promoter who is generally fighting to get the company back will come back, or should they listen to this insolvency professional who is a court appointed officer governed by the financial institutions. That's one. The sector which I feel gets significantly hit, and I say this with all my heart, and I've been saying this for the longest of time. I wish at some point the government does something about it. The people who supply goods and services, they are called the trade creditors or the operational creditors in the terms of IBC, but they are the ones who supply goods and services. They could be your vendor, basically, simple vendor to you, giving whatever it is.
Even shopkeeper also.
Shopkeeper also, yeah. Those guys. It could be your suppliers of IT services and all of that. They come right at the end of the supposed waterfall mechanism by which if a company is acquired for, let's say, 600 crores against a debt of 4,000 crores, 600 crores will go off to the first class itself, which is basically first the cost of running the process, secured creditors, workmen, possibly something to the employees. Very rarely we see that there is any money left to trickle down further to unsecured financial creditors, government dues, or for that matter, the operational creditors. Now think of it, assuming you are an MSME company, you're a medium-sized company, you're a manufacturer. You have supplied material to 20 companies or 10 companies, 10, you have 10 large customers. 4 of them have run the insolvency process, unfortunately, to your bad luck, which happens. But out of 20, 4 have run. And in those 4 companies, your exposure was, let's say, 60-70 lakhs each.
Exposure as
exposure, matlab your credit, and that much of material you had supplied, they were supposed to give you 2 months, 3 months. It's a running credit. It was there.
Okay.
Now, assuming that against that 60 lakhs, for example, per company, you get only, let's say, between 5 to 10%. Take 10%, 6 lakhs, which means against 2.4 crores from 4 companies, you will get only about 20-25 lakhs. Now, what do you do as a business? You are doomed. You will then have to, for all you know, run the insolvency process for your company. So that's one area where I don't know why, but the law has been fairly harsh, I would say, on the operational creditors. This issue has been agitated by the stakeholders before the Honorable Supreme Court, and Supreme Court has its perspective to say that no, this law was for financial creditors, for financial institutions, and there are certain reasons why they should be given a preference and a priority, because they are the ones who are the lifeline or the backbone of the financial this thing of the company. But if they are the backbone, then I would say the operational creditors are the lifeline, or vice versa. Because if you don't have vendors to supply you, then how will you run a company? So sometimes a counter argument that comes in when I get into some of the discussions is that the vendor very well knows what is his or her exposure, or what is his or her going to be a risk in the company when they're supplying with the company. My counter answer to that, or counter question to that, is how many vendors today have security against the amounts that are due, that are owed to them by these companies? Most of them don't have. Maximum you will find some of them will have some post-dated checks which they can use for filing some criminal cases of check bounce. So that's one sector which I think needs addressing. Like home buyers, for example. Home buyers were in a pretty gray area situation earlier, but as the law evolved from time to time, JP Infra and then other projects and Amrapali and all of that, today the home buyers have a say in the insolvency process. They form a part of the decision making body. It's not so easy to just walk over home buyers under the IBC.
Who are these home buyers exactly?
These are home buyers, basically these are people who have paid money to builders of incomplete projects, and the projects have gone into insolvency, have gone into IBC, have got into a status of financial distress, as a result of which they have been admitted into insolvency. So while the financial creditors, the bankers are taking decisions, these home buyers who have also invested in the project also have a say in the resolution mechanism and the resolution process. So similarly, I believe that the operational creditors should have some say or some protection at some point. So the sooner it is, the better. Maybe the law was brought in 7 years back. At that time, there was something which was the need of the hour to somehow save or maybe safeguard our banking system, or save our financial, monetary system, financial system, or the banking scenario. NPAs, non-performing assets. I think we have come a long way from 11% NPA in 2000, I think 17-18, because that is when they started declaring NPAs, to I think our non-performing assets as on 31st March 2023 is about under 4%, 3.9%, which is a very good ratio. So I think it's time for the law to now start looking at other things as well, other stakeholders and their concerns as well.
So, since we are talking a lot about terms and conditions, whether it exists with the buyer or with the seller, whatever it is, even from a normal context of a regular human being who doesn't want to, indulge in this sort of things, there's one thing that you had touched earlier in one of your articles, as well you addressed this in one interview, that was related to contracts. You were explaining that what the contracts are about, which is signed between a person and a company. Provided we live in an age of social media, where even if we have to download an app, we first have to agree on terms and conditions that we don't even bother to read, and we just click on the tick option and we install the app. So from there to this social media gambit, it's way too broad, to these businesses where things are very formal and things get directly into the court. What is something that a normal person should be aware about when it comes to contracts like these?
That's something which I think is very relevant, and thanks for asking that. I think a lot of people need to know that the importance of contractual terms, the relevance of it. Now see, when I will only slightly widen the question that you have asked.
Please.
A contract need not even be between a company and an individual. It can be between two companies. It can be even between individual A and individual B. So the terms and conditions of the contract, whoever are the parties who are signing, whether it's the company and the individual or whichever way, they bind these parties. So it is important that when you sign a contract as a signatory, irrespective of what is your type of your entity or your person, you should know the content, you should know what the contract is about. At least the key clauses. Are the name of both the parties reflected properly? Is the intent why this contract is being entered into, is that reflected properly? What are the rights of both the parties? What are the obligations of both the parties? Why are we entering into a contract? So that we put everything in pen and paper, in simple man's, and I would say common language, right? So that we know, okay, you will bring money on the table, I will work together with you, I will do the hard work, you will bring the money, we come together as a collaboration. Or maybe there's a third party who's bringing in, let's say, some branding, and together we do this business. If the business does well, revenues will be shared, so and so. I'm giving a typical partnership kind of a model. This, you can call it as a joint venture, you can call it as a partnership or whatever. And then also, what are the in specific obligations, confidentiality clauses, all of that is important. How are you governed by confidentiality? How is the other party governed? Then in terms of what happens if there is a default and what constitutes a default of the obligation of either party. Suppose I've committed to you that I will exclusively work with you for the next 1 year as far as this particular business is concerned. And let's say my geography is India. But if I go and start parallelly doing the same business with other companies or other such players, which means I'm in violation of this contract. What is
because it's not it's only relevant in India, you were saying, the contract.
Whatever, I just gave an example of India. Suppose if my commitment to you as part of a contract is that I will, let's say, do a certain product marketing in India only through you for the next 1 year, starting from today. 3 months down the line, I sign a similar contract with someone else, maybe diluted or irrespective of what I sign. You realize that I am already started engaging with other companies for similar contract or for similar work that I've asked you to do. I've asked you to market my product and distribute my product. I'm doing the same thing with 3 other people. Obviously, I'm hitting into your revenues, what you would have, because you've taken pains, you've set up logistics, supply chain and all of that. You've reached out to further distributors and whatever it is. Now, what remedy do you have against me? You need to know that. Is this called the breaking of the contract?
So basically you're sort of doing the benching here, as in you got a better deal as a contractor and you signed it with me, for example, but with me you saw that you are not getting this and you are getting a better deal with someone else. You're going to them, but you're still keeping me on the hook. It's like this, you're saying.
Not exactly. No. I'm just giving you an example where there's a possibility where I have entered into a contract with you. There could be any kind of violation I could do. One example I gave was committing with you and then parallelly doing business with someone else. Or my contract with you will also say, let's say, whatever products I supply to you would be of a certain set of specifications, A, B, C, D, E. What if the specifications are not matched? If I am committing to you that I will give you the product at a certain, whatever, international price so and so with a variation of up to 5%. I start charging 30% on top of the international price range. So anything which is against the spirit of the contract or against the words of the contract or spirit of the contract, that would be seen as a violation. So that is what you call that I have defaulted in my commitment. Now you have to take a decision as to what do you do to bring me back on track, for which we have something called a dispute resolution clause or a clause wherein in case there is a dispute. So now this is becoming a dispute between the two of us. How would you resolve it? There are various mechanisms. There is mediation. There is something called arbitration. You could go to court against me. You can stop me from doing business from a third party. All of that is there. But the important point is, mostly we have seen this with experience when people or companies enter into businesses Especially, it's a request to the startup sector. If I know your podcast, you have a lot of younger viewers, startups who are looking for angel capital, seed capital, so on and so forth. Please read the contract. Please read the terms that you're signing in for.
Or better, get it done by someone professional, right?
That is ideal, but I also understand, having dealt with a few startups, depends on what stage your startup is. If you've not even got your first round of funding, or you've just got a first round of initial, some very basic friends and family funding or angel funding, you may not be able to hire a professional. Ideally, if you can, nothing like it. But if you can't also, I think please read, please see what the investor is making you sign. See, I could go on saying that, and I believe in this, that a lot of these contracts, which are otherwise 50 pages, 70 pages, 80 pages, the crux of that can be actually captured in 5 to 7 pages.
And how one can figure that out?
It's doable. It's just that we are following a certain style of drafting over the years, where everything is extremely verbose, very detailed. Same thing is written 3 times or 2 times, or the same things are put in an extremely elaborate manner. I'll give you an example. Now, there's something called, before signing into a proper contract agreement, a lot of companies enter into something called a term sheet. Term sheet is nothing but a tabulated column where on the left side you will have one thing called name of the party, and the right side you will have the two names, A and B. Next row, validity of the contract, validity will be mentioned. To the point, issue, and the exact terms. This whole thing is typically, from what I have seen in most of reasonably decent sized contracts, running into tens of crores, maybe not hundreds, but tens of crores also, or it can actually even be for more than that. The crux of a contract is what is captured in a term sheet. That comes in about 6 to 8 pages, 10 pages at max. When you convert that into an agreement, see, I know definitely you want to protect. I mean, we as counsels, we as lawyers, we definitely want to protect our clients, and all of that is there. But I don't know how that 8-10 page document becomes a 100-page contract. That is something which is beyond understanding. At least if I understand, if a 10 pager or a 7-8 pager can become 20-25 pages, it's still okay. I'm giving you, see, whatever I'm saying, this is not in black and white that every contract becomes that detailed. But I think as a policy, younger companies, the shorter they have, or the I would say brief agreements, documentation that they get into, brevity is key, not being verbose. So if you can have it short and to the point, it makes a lot more sense, because you will understand, the other person will understand what is written. A 2-page document is a lot more readable in simple language. If you see, there's a difference between a memorandum of understanding and an agreement. There's something called MOUs.
I was about to ask you that. Are you reading my mind or something?
No, that's just...
Please, about MOU.
So MOU is sometimes a precursor to a proper agreement. Now, how is it that the MOU is again very brief? It's like a 3-4 page document. But when that gets converted, and those are in normal English language.
Even annexure is also there, right?
Yeah, annexure can be in the MOU, it can be in the agreement also. That's a different thing. Annexure is basically where you have to put specifics of some specifications, or annexures can be used for multiple reasons, which is fine. That's sometimes required. But same MOU, when you convert it into an agreement, as much as you may want to ensure that the parties are protected, or at least your client is protected, I think all I can request both the startup, the startup community, and I would say, of course, there are a lot of younger lawyers who are now learning. I mean, they are drafting shorter contracts, shorter agreements, because they're realizing that the startups are not very comfortable signing those. But what happens is, we've seen startups where they've struggled for 5 years, 7 years. Finally, first round of funding is coming in. So they will obviously not read the law. Now let's take it to the next level of when you are buying, let's say you take a home loan or a car loan. And this is something which I personally feel very, this thing about. I wouldn't use the word upset, but I'm not able to understand this logic. For a 8-10 lakh rupee car loan that a person like like if I have taken that and I know what it is, I would have signed some 50 sheets of paper, indemnity, guarantee, assurance. Basically, for that 10 lakhs, I've written my skin. If anything goes wrong, they can go behind me. They can go behind, I don't know.
Even your guarantor, I guess.
I'm a guarantor also.
Yeah.
Yeah. So it's okay. That's a policy of the bank. That's fine. I'm not, because at the end of the day, why are we all talking about strengthening our government policies, banking policies, to ensure that it's a rule abiding country where people realize because you can't default. We're going back to the first point. But at the same time, at least in the past, people have taken hundreds of crores, and I'm not sure if they've signed so many papers. But to coming back to your question, that is it important? I would say it's very important that when you are signing agreements, you should be very, very well aware of what you're signing. An extension of this is also something which I tell a lot of family businesses, small family businesses. What happens is you've taken a loan, 50 lakhs or 1 crore. You're expanding your business. You need additional 25 lakhs or 50 lakhs. The bankers tend to say, sir, you don't have any further collateral to give, any further property to give us personal guarantees. Personal guarantee means if anything goes wrong, the bankers, and with the present law like IBC, they can come behind your personal assets. They can auction it out there, and it can go towards a stage where you're declared as bankrupt. You as the businessman signing the personal guarantee, that's your personal choice. But by and large, more than 75% of Indian family-run businesses have their family members, their parents, their spouse, having signed the personal guarantee. That family member, being the spouse, typically the wife or the husband as the case may be, more so the female family member, and the parents have nothing to do with the business. They have no clue about the business. They know there is some business that the person is running, the bread earner is running. You're realizing that in the quest of trying to either expand or grow or get more credit from financial institutions, you are exposing your near and dear ones. And if, God forbid, something goes wrong financially, the business goes down, see, you should be prepared to let go of your collateral, your security, because that you've given to the bank. Bank also needs to secure itself for you to give you a loan. Your personal guarantee, fine, but not of that of members who have nothing to do with the business. So that's one more thing which I strongly urge people, small and mid-sized companies, younger companies, startups, think not once, twice, 4 times before giving a personal guarantee. The counter question that typically comes is, sir, without personal guarantee, nobody is giving us loans today. I know it's difficult, but I think there are schemes like the Mudra scheme of the present regime. There are some specific banks which have SME cells, which have startup cells. Possibly you can look at those. So I'm not saying you go for exorbitant interest-oriented thing from private lenders and all of that. No, I'm not for that at all. But please be very cautious of what you are signing.
And you didn't touch the social media factor, as in that was just an example that even for an app to download, you have to accept some rules and regulations, then only you can download it. Similar thing, I guess, sometimes happen with a general person, as in they have to sort of, it's like a necessary evil sometimes. They have to agree on some terms and conditions that's been set by the government or the governing body or wherever they are. There are some terms and conditions which they cannot select or they cannot opt out of it, but they have to sign it so that they can proceed towards whether it's professionally or personally, whatever the matter is. So how one can deal with matters like those when the autonomy is not with you? Like these contracts that is between business and entrepreneurs can be edited, but not in this case, I guess.
I agree with you 100%. I don't have I will not make a counter argument to it. I gave you my own example of the contract of the loan I took for the car. Now, I can't go and negotiate saying that I will not give personal guarantee, I will not do this or I will not do that. Those are set format printed contracts. Something similar to your social media, I agree, wala ticks. So they are set formats. There's not much that you can do. But yeah, that's what it is. The area where, so I will put it this way. See, where you cannot negotiate, you can't negotiate if it's a government tender, government contract, financial institution, public sector bank, to some extent even private sector banks. You can't. But at least where you can, with your business partners, with your vendors, with your employees. And now, for example, employees, how strong is your non-compete, non-solicitation clause, or a clause where they don't take away your intellectual property? How strong do people have that with their employees? Most of them don't even have it. I think you're giving me a look where you're a little lost. But my simple point is, people who are working with you, they leave you and go. They can just take away with them your clients, your intellectual property, your ideas, your data. What would you do? So your employment letter that you sign with an employee have these basic things in place. But I agree, you may have a question, sir, we don't know these things. I mean, when the problem happens, we realize, yes, so something has happened, has gone wrong. But I think today, complaining or rather saying that no, there is awareness is not there. Compared to, at least I would say, in the last 5-7 years with all the social media booming up so much, I'm sure there'll be people, and there are some people on Insta, at least I know Instagram, that who try to spread this kind of awareness as to what is the relevance of a clause that you're signing, a document that you should have. And if not, I hope whatever little bit I'm saying now, this reaches out to the people.
We will get viral. The podcast will get viral.
Because they need to be safeguarded. They need to secure themselves.
But how unjust is this sometimes? Just to put this in perspective, as a middle class person or as a person who is economically at the lower strata or the middle strata of society,
fair enough, yeah.
You have to go through the regulation and all that stuff, and then you finally get a huge or decent chunk of money. Well, in comparison to these big business leaders, you see, they do money laundering scams and still they are setting out free, roaming around, traveling and doing all this stuff. So how does this work for them? Provided there have been so many web series also made, like on the Harshad Mehta scam, on the Telgi scam. Multiple incidents like this have been covered, not only in India, but rather in the globe. So how does this happen at the higher level of strata in society?
This is what I think you want to go viral now with this. Harsh reality. I agree to a large extent what you're saying, but not completely. Harsh reality being that I totally agree with you, because I associate with that sector that you're talking about, which is either, if I may call, the middle class, a little up or a little down, but the aspirational middle class, which is now kind of rising in India. So yes, we have to struggle a lot to possibly get a loan of you're talking about big amount. I'm talking about 10-15 lakhs also. Show me a loan on 15 lakhs. Is it that easy to get with a simple setup that one may have, or a simple infrastructure that one may have? Bare minimum, you need to have at least an apartment to mortgage that. Now coming to the larger industrialists and this, whatever you took a few names and all of that. This again goes back to a time where these scams, see, like for example, Harshad Mehta. The entire capital markets scenario then was very loosely regulated. It led to somebody taking advantage of the system. You had a scam. Similarly with Telgi. Telgi was a different thing altogether. Stamp papers and so on and so forth. But surprisingly, I would say these scams, corruptions, scandals, we saw them even as late as 2008-9. And unfortunately, as much as you may like it or not, if truth is to be spoken, there is a nexus of, at that, I mean, I would say at that point in time, whoever was the ruling government in power, and industrialists, and that's why, I mean, there's a list of willful defaulters which was out there. I think it was presented at the parliament or somewhere. 31st March 2022. Gitanjali Gems and Jewels, Nirav Modi's company, some 6,000 crores of willful default. Total amount defrauded is 12,000 crores. So how did this 12,000 crores came out of what? Of fake letter of undertakings. Basically money out of thin air. It happened. So, which meant that there was a nexus, and they were part of that nexus, both the business people who were involved in this, political brass to some extent, definitely to a large extent, and bankers slash bureaucrats, I would say, they would, there was this term that used to happen, that phone banking. You would get a call and then you have to sanction a loan, even to a company which has gone a little, I would say, negative. So these challenges did take place. But I think this is where I believe, again, I'm not getting too technical. I would be happy to, but I'm not. See, there are a lot of these RBI mechanisms that have been brought in, tightening of norms, tightening of like for something called the Basel III norms that are being introduced, where banks have to have some more. If the exposure of a private sector bank is X or a public sector bank, 10 or 15% they have to keep as a reserve with them at any point in time. So these are mechanisms by which banks are also put under surveillance and under pressure not to lend left, right, and center to these so-called big industrialists and corporate houses. So what we are trying to do is hopefully ensure we put a system in place. One, the mistakes should not be repeated, what were possibly done years later, maybe a decade back or so. And secondly, we put a system from here going forward where chances of loopholes, chances of these kind of issues are, I would say, I would hope next to impossible, but once in a while you would always find somebody who will find a way to
Fool the law.
peck through the system. I'll give you an example. I told you about Insolvency Code also. A law which I've written a book on. I have indirectly indicated that, and I've said this on podcasts. The problem is you can't go and make paper trail, but there are Indian companies, Indian promoters who have acquired their own companies through a third party entity which you can never figure out that there is a connection. The third party entity has some trust in British Virgin Islands or Cayman Islands. It comes through Singapore, UK, and all of that. And then the money comes through a clean company. And that company becomes the bidder of this any XYZ distressed company and acquires the company. After 3-4 years, the shareholding or the entire ownership of the company will be given back to the promoter. Or the promoter may not take it in his or her name, they may run it through somebody else. So loopholes, unfortunately, are always misused, and they're there and they are misused. But again, government is trying to see whatever best they can. They're tightening as much as they can. But I would say our legacy of challenges are so many that one at a time.
Definitely. Moving towards a different genre here, about more of like Indian law. You had written an article about UCC in Uttarakhand. So, when you talk about UCC and the whole idea of controlling relationship, marriage, or even live-in relationships specifically, which was the very controversial topic, there is this very image amidst the young crowd that they don't have any autonomy over their own personal relationships. As in, there is this rapid development that we are having in the country. That's obviously there. We are also saying that we are liberating ourselves, we are moving towards a better and much accepting world or a much accepting country. But again, when things like UCC comes into a picture, then this sort of is like a very bureaucratic or a very law wala way to control something as private as relationships. So how would you like to describe that?
Okay, so with respect to the Uttarakhand Uniform Civil Code that's come in recently, before I address this issue that you raised with respect to live-in relationships being regulated under the Uniform Civil Code, there are definitely a lot of positives in this code as well, wherein a lot of personal laws have been made unified, common, codified, so that there is no discrimination, number one. Number two, with respect to the specific issue of relationships, see, the intent of, at least from what it looks like, the intent of the government seems like there should not be any illegitimate or there's a larger thing, and this is what I see. There's a larger objective of this. Yes, sometimes for achieving larger goals, sometimes there is a collateral damage that could happen, is to ensure that there is no illegitimate kind of a Kerala story situation happening in these places, wherein under the garb of a live-in relationship, there should not be something which is a larger danger to security or some concern, security, national security, threats, concerns, so on and so forth. But it is not fair to bracket all of that under one shell to say no, everything is going to be risky. The other way of looking at it is live-in relationships have been, in a way, I can say, legitimized by the government. So there's one whole argument that this is a progressive thought process, that at least we are giving it an official status. Children born out of live-in relationships will not be termed as illegitimate children anymore. They would be, that is what the UCC of Uttarakhand says. They will have the fair legal right as a heir to the parent and so on and so forth. Now, yes, there is definitely a sense of concern. I can say some places criticism, some places concern by the younger generation to say that no, this is kind of getting into our personal space, because when I get into a live-in relationship, I need to register within certain number of days with the local sub-registrar or whatever it is, authority. And even when there is a moving out of the relationship, they have to be notified as well. So here I would say, yes, we'll have to wait and watch whether this is being productive or counterproductive. Because see, even the authorities will then have to become that sensitive, that mature, that it should not become a reason for them to, if I may use the word, harass the younger generation. Because today you go and you say anything which is not making sense or logic to the today's, I would say, 18 to 25 or 20 to 25, or that age bracket generation, or maybe up to 27, 28, whatever be the, as they call it, the youth. You will immediately have Twitter trends starting. You will have a lot of outbursts out there in the social media. That's one thing. Also, if there is something, as of now, there is no challenge to the UCC yet of it being unconstitutional. But if there are going to be any developments where there is any factual incident happens where it is seen that the authority is misusing the power of governing or trying to the big brother attitude in a live-in relationship, I'm sure the courts will intervene. The courts will step in and say that's where a lot of times even a law is put into place. You cannot anticipate on day one everything that's going to come in the way of the law, good, bad, ugly. So I think that's why you should leave it to the honorable courts to interpret and see what should be the parameters, what should be the benchmarks, so on and so forth. So that's, at least I would say, my take on this aspect.
Do you feel the liberalization when it comes to execution? Because obviously police is there, your governing bodies are there, but at the end the matter comes to court. From sensitive matters to acquiring of lands, to religious issues, to personal issues like relationships, everything at the end of the day comes to court. You are also aware of the fact that courts are already overburdened when it comes to India. And then you also want innovation, you also want to change the law, you want to break the so-called colonized stereotypical idea of law you have. Do you feel India is moving towards the way to become a liberalized country?
More than a liberalized country, I would say India is working towards being a more, I don't know if I can use the word citizen friendly, or to put it in more younger language, I would say user friendly kind of a legal system. See, liberal, yes. And my answer to the basis for the yes is there have been about 19 ministries under which about 43, 42 laws that come in. And under that, 180 plus sections under these 40 odd laws have been decriminalized, which means that the provision was, if you don't do this, you would be put behind bars. That has been taken off. Only fine is there. Similarly, there have been a reduction in a number of compliances, legal compliances. Some say 30,000, some say 50,000, but whatever be the number, there has been a reduction in the number of legal compliances. More than about 1,200, 1,300 old archaic laws, they have been knocked off, repealed. They did not make any more sense, so they have been repealed. So there are measures being taken in the judicial side as well. Now, whether you call it as liberalization, yes, you can call it that the legal system is getting a bit more liberal, but my larger concern in the legal system is the lack of legal infrastructure.
Legal
And-
infrastructure.
Yes. That's my larger concern. Because, yes, irrespective, see, laws can be good, it can be sometimes not so good or counterproductive. The courts are there to interpret the law. The courts are not there to make the law. Law is being made in the parliament by the lawmakers. But if the strength of the judiciary is less, when I say strength, physical strength of the judiciary is less, how do you expect justice to be delivered? So that is where I would say my larger concern lies. And you have vacancy of about 30% in high courts of judges. Lower courts, you have again a vacancy of about 20% plus. Your support staff is 27% vacancy. There was in October or November 2023, there was a national judiciary report that had come out, if I'm not wrong, as on 30th November 2023. And it gave a lot of, I would say, interesting figures to show both the challenges, the good things that have happened, of course, but also the challenges and the way forward that we need to more, I would say, move towards, as I said, online courts, so on and so forth. Like one good thing I'll tell you what that has happened is that more than half the high courts have now started live streaming of their proceedings. So there's transparency into the system. 12 billion pages have been pages of documents have been digitized. So we are moving towards a digital setup of judicial system. Sooner or later, I'm expecting artificial intelligence will also play a role in at least ensuring that very procedural things can be taken care of. But then even today, unfortunately, there's a shortage of even courtrooms. There's a shortage of basic judicial infrastructure is all I can tell you. But at the same time, I also believe the solutions are there. I will draw an analogy from the Highways and Roads Department, the Judiciary Department. Prior to the present Highways Minister, Mr. Gadkari's work, India was making, if I'm not wrong, certain X amount of kilometers of roads per day. I think in the previous regime, some 16,000 kilometers of roads were made in about 9 years or 10 years, around that time, or could be around plus or minus. 47,000 kilometers of roads have been constructed in the last 9.5 years. The per day construction is 2.5-3 times. How is it that so many highway projects are coming, minimal litigation, minimal land acquisition problems, and highways bhi aa rahe hain, things are all happening, it's falling into place, which means if the man on the top knows what he or she is doing, the message flows down right till the end that the job should be done. No compromises. Now let's take that and move this into a judicial infrastructure setup. I am not saying that we have to blame anyone. Why don't we take a cue from that and ensure that to run or to ensure that our judiciary is effective, give the job to somebody who is able to, for example, they say to acquire land, to set up more courts, it takes years. Why should it take you years? Take faster decisions. Decisions are being taken. I mean, from policy paralysis, from that time we've come to a large, we've come a long way. But then a lot of things can further get resolved a lot more faster. And long and short of it is you will have more judges, you will have more courts, more disposal of cases. The other things which are good are happening. Mediation Act has been brought in, resolving issues without getting too much into courts. About last year, about 1 lakh cases were resolved through mediation out of 4 lakh cases that were referred to. One another good step that has been happening on the legal side is this bringing in of the Real Estate Regulatory Act, this is RERA as they call it. About 1 lakh plus projects were administered or were registered under this RERA authority, which means builders can't now just start a project, take money from the allottees, divert it to project B, then take some money from there, divert it to project C, which used to happen in the past. All of that is being slowly regulated with new laws that are coming in. Laws are there, but are you able to enforce it? You need
That's like a synergy between judiciary and the execution.
judiciary, executive, yes, to a large extent. That needs to be established more to ensure we have solutions.
Yeah. So, Anand sir, seeing this conversation, to moving towards the end of it, if there is something that I was actually figuring out what sort of question or what sort of topic I should pick for the end. But I figured out I'm talking to a lawyer. This is the best thing that I can ask. You're someone who has obviously read law, understood law, and obviously you have written the book. So there's a lot of research that is involved there. You must have gone through a very hefty amount of research, to be very frank, various interviews, meeting a lot of people, and obviously drafting and fighting a lot of cases. There are people in India which pretty much have lost faith when it comes to Indian law. मतलब अगर हमारा चालान भी हो जाता है तो we prefer to bribe the police person rather than settling down in court. I mean, that's the amount of faith that this is a long process. That's the typical Indian mentality when it comes to court. So if that is being kept in this picture, and as a lawyer, when you hear it, what do you feel about it?
I feel bad about it. Unfortunate, it happens. But I cannot deny it either. It does. I can't have, it's difficult to give a black and white answer, but I can give you a few perspectives to this whole issue.
Scale more of.
Grayscale and a few perspectives. One, yes, sometimes you just want to get rid of the thing then and there and you don't want, any hassle. The example that you used, you do that. But I am in no way propagating it. But the answer to this is, one, this is again a legacy issue, the way we have been, and if you see what has been our Indian ethos, the way we have been working, the way we have been conducting ourselves, ki pay money, get the job done.
Bribery is in blood.
that is unfortunately an ethical issue. It's more of an ethical, if you go a little deep down to see, it's an ethical issue. I very strongly am a believer of this concept, and it may be a complete detour from the conversation that we've had this far. But at a personal level, I'm a believer of both dharma, and I believe that long back, 2000 years back, Kautilya, Arthashastra, that is Chandragupta, this guy, Chanakya, the mentor of Chandragupta Maurya, he wrote his Arthashastra where he touches upon this whole concept of dharmic capitalism. Now, the long and short of that is, an economy can be built strong, an economy can be built well, governance, taxations, with zero or minimal corruption, but with strong ethics. So my response to that, while a practical response will only be that, yes, we are already doing a lot of things and possibly we will be, and we have to do that. So it has to be a multi-pronged approach. At a practical level, make corruption a mega crime in this country, so that the giver and the taker both think, no boss, I don't want to do this. And of course, but then facilitate the wrongdoer, and if it's just a challan issue, facilitate, you pay through your UPI then and there. Don't get harassed by going to some place and losing out your time. So you don't mind it. You're willing to pay that guy 300, 400, 500, whatever it is. You do a UPI to the government and you've done something wrong, you pay for it. So I think that I don't think you would mind doing. Now coming to this point of the larger approach, which could take about 10-15 years to show results, which is okay. But if we are talking about advanced countries, India, Viksit Bharat, 2047, 2047, whatever we're discussing, if you see in the last 4-5 years, it started right from the last 8-10 years back, but the last 4-5 years, there's been a lot of importance given to the Indian ethos. Unfortunately, spirituality is termed as religion which is not the case. Spirituality, I would say dharma, ethics is a little different kind of a thing. At least I see it different from religion. I will not even get into that area as to what is religion, and that's not my core area. But if we can instill a sense of ethical business, ethical way of doing things in academics, in education, in business, in banking, in all the relevant sectors, we start instilling it now. Trust me and take my word on this. The next generation that you will see, which is 15 to 20 years down the line, they would deter corruption. They would not accept that, tolerate that. As it is, tolerance levels of the younger generation is very less, and they are vocal about it, which is also fine, which is good. So imagine if they are ethically rooted, that's also going to make a world of a difference. So to connect this to your question, that there is, you see that things are happening, going wrong, and you're helpless, and you just think, okay, let's pay money and move on in life. I think it would take some time, but I think we should get there. But you'll have to start instilling it now at the, I would say, level where our kids learn this, so that over a course of maybe next decade, we will start seeing the results of that. Practical level, yes, make punishments more and more, I would say, difficult, or make more harsher punishments for something which is, like, for example, corruption. Like I from my interest of Arthashastra, there was no scope for people in that era of with respect to corruption, because he uses certain examples where especially government officials were very strongly watched under surveillance. There were spies, there were internal people who would closely watch people working in the bureaucracy at that point in time, 2000 years back, to ensure that corruption levels are either nil or as minimal as it can be. So when someone can think about it 2000 years back, I fail to understand why can't we start reworking on it and instilling it into our, I would say, overall ecosystem. And here I would not say specific to one sector, just the bureaucrats or just the government. It should be across everyone. So I think that's the only way that we can. But that's your long-term solution. Short term, you will put in some penalties. You will, maybe one government comes, they make things strong, they make enforcement strong, good. Maybe the government continues for a couple of terms, great. But what in between, you have a situation where some government doesn't focus on this and focuses on something else. You're back to square one. So yeah, I would look at it on a more optimistic side to say that we have some good future ahead of us.
I hope so it becomes pragmatic too. And I guess that was pretty much all from my side. Apart from my dilemmas that I had regarding economy, I hope I was able to do justice to this conversation. I hope you had a great time. It was a learning experience for me to learn so many technical terms related to economy. And thank you for being on AP Podcast.
Thank you. Absolutely a pleasure. No, I'm sure you've done a great job is what I should tell you. And
I hope that's a true
no,
compliment.
you've done it, and I'm glad we kept it more open and this thing, so that people are able to connect to it more than just it being a legal conversation. I hope I've tried my best not to use sections and specific provisions and case laws to the extent possible, and I hope people have some takeaway from this. So thank you so much. Thank you once again for having me on your podcast.
Thank you. Pleasure is all mine.